James, just before we start again, just a very short matter, if I may. A typed letter was delivered to the court just before the short adjournment, addressed to me. I have shared it with the Constitution, and I just need briefly to tell you what it says and where we're going from here. It's typed, as I say, and it's addressed to me at the Court of Appeal. It says at the heading, "We oppose genocide, we support Palestine Action." There is then a typed list of signatories, which we haven't gone through in any detail, hundreds of names, both national and international. We propose to ignore the document completely for the purpose of this hearing, but simply felt it right that we should alert you to the events that have happened. And there it is. Thank you.
I should update you, if I may, on the form of the order that we were discussing at the very beginning. Right?
Yes.
I'm afraid the matter is still slightly subject to an ongoing discussion.
Yes, of course.
There's a little bit of concern expressed, and as we've arranged to have a bit of a further chat with those engaged in the criminal process after court to see what can be done.
Thank you.
I was rather hoping it might just be a straightforward, do it in this way, changes in this way, and it'll be fine, but it's not quite that. So a bit further to go on that point. Articles 10 and 11, I was going to turn to, if I may. Skeleton 58 to 76. We find that. And just by way of starting point and context, as a lead-in to the interference issues and the Article 17 point, just a starting point and context that I may start off with. And we respectfully submit that the starting point and the context for any consideration is that Palestine Action is an organisation involved in terrorism within the test provided for by Parliament in the primary legislation. There's never been any challenge to the finding that they're involved in terrorism, nor is there any challenge to the primary legislation itself on VARIs or HRA compatibility grounds. The prohibitions, as I set out in opening the statutory context, in the primary legislation then apply to all on the back of prescription, in essence supporting, in the variety of ways specified in the primary, that prescription. The divisional court, again as I alerted you to in opening, the divisional court held that it was not sustainable to portray Palestine Action as a non-violent organisation, judgment para 29, that Palestine Action encourages the causing of more rather than less harm, 25. They recognised that it was an organisation concerned in terrorism, 92 and 134, and in that context they held that it wasn't engaged in any exercise of persuasion, or at least not the type of persuasion that is consistent with democratic values and the rule of law, a specific finding to that effect in 23 of the judgment. And they also found in 137 of the judgment that any such action is, as they put it, the antithesis to the notion of a democratic society that is the foundation of the European Convention on Human Rights. That's 137. Against that background, they also concluded at 108 that it is settled law that convention rights do not afford any protection to violent or non-peaceful protests. And we submit that was a correct recognition. There is no right under any of the relevant articles to be a member of an organisation that is within the convention-compatible definition of terrorism, or that engage in acts of serious property damage, whether accompanied or not by violence to the person. And the nature of that set of issues was considered in some detail in the Attorney General's reference number 1 of 2022. If I can invite you just to take that up briefly, if you would. It's the Authorities Bundle at tab 33, page 1213 in the electronic. Authorities 33 starts at 1179. Perhaps you start there with the head note so you can see what it's about. Can I just invite you to read the first 6 lines we'll probably do of the head note, just to give you the flavour.
Yes.
And then 1213, there's a useful analysis I respectfully submit. You'll see the composition of the court on that 1179 page.
Yes.
Burnett, of Malden Chief Justice, which now has to be added KG.
Indeed.
And the paragraphs I wanted was 79 and following, 1213. The scope of the protection given to protest by convention rights. Do you see that title?
Yes.
And the key paragraphs that are perhaps of interest, drawing the distinctions they're drawn, as you will see, it's probably sufficient for me to invite you to read 82 through to the end of 87 first, if you would.
Yes.
And then 90, particularly the first sentence.
Yep.
Yep. And then pulling matters together, 102 at the bottom of page 1217. Now I'd like you to read two summary paragraphs. The first one is 102, and the second of them on 1219 is 110. So 102 and 110 will give you, I hope, all you need.
Yes.
So that, I hope, is a helpful indication of where the Court of Appeal drew the line, or drew the lines up in that case. The core message I respectfully submit from those paragraphs is that damage to property forms no part of protected rights, at least if it's beyond the minimal level. De fortiori, that applies if serious damage is what is required, as we know it is under the definition of terrorism in the 2000 Act. That is especially so if the property damaged is private property. So the Convention values protect and only protect peaceful protests. And indeed, there's a clear acknowledgement that damage to property can be violent.
Does this mean that the min sub was wrong to say that a proportionality exercise under a convention-compliant proportionality exercise needed to be carried out?
My lady, I'm not sure necessarily wrong. I don't think there was specific consideration of these points, but it was plainly sensible for the Secretary of State to have done that exercise anyway. There was no guarantee that a court would accept it being outside, as it were, the total protection of ECHR rights, and I'll come to the Strasbourg case on that directly in a moment. But
if you're right, there
I'm
would be no need to carry out a convention-compliant
need to go on
proportionality
if it
exercise,
fell outside.
and the min sub and all that's wrong. Okay. Is that
This simply says it's all right to have the criminal offence of criminal damage. It doesn't tell you the next stage. What about making other things for other people a criminal offence? Does it go that far?
My lord, it doesn't. It was directly concerned with the nature of the criminal offences that it's like an ABJ case. But so one's got to take what one can from the analysis of the nature of convention rights and then apply it to the different contexts. It's maybe part of the reason for not take quite a bold person to submit to the Secretary of State that says you don't need to do the proportionality exercise at all under the ECHR. They should consider that anyway. But that's what we get from that case.
Well, surely the problem is you have a number of people who are definitely not doing any more than peacefully protesting, and the only thing they do is support Palestine Action, have a placard or whatever it might be, which becomes terrorism only when the organisation is proscribed.
Well, that is true. That is true, and the only thing to add to that, which I'll come back to, is that at that stage also they are in a position in which proscription has happened, and so they know or could
I understand that, but before prescription has occurred, you have to take into account the rights of such people.
Yes, you take into account those rights as part of that package, and no one is suggesting that it is restricted in its effects.
So the point I was making, Sir
Right.
James, is simply that not to undertake a proportionality analysis would have been very risky indeed, I think, not just because of the outcome.
But because those rights would also
Reason I
need to be
get,
factored in. What you'd be directly considering at the proscription level of the organisation would be an organisation that is engaged in violent protest, if violent protest covers criminal damage as it appears to. I turn to Article 17 and the scope of Articles 10 and 11. First submission is that the activities of Palestine Action were caught by the test in the European Court of Human Rights case law. The nature of the test in that respect set by Article 17 of the ECHR and considered in ROJ TV, R-O-J-TV, at paragraphs 30 to 38. That's authorities 65, 2458. Test, in essence, is statements directed against the Convention's underlying values or acts aimed at the destruction of the rights and freedoms laid down in it. 31 of that little section. And we submit that on that test,
So which paragraph?
it's really 30 to 38 in ROJ.
Right.
And the bit I gave you was from 31, which I hope should be sidelined.
Yes.
As they said, alongside that, this is all about statements made by people. That alongside that is the Court of Appeal's analysis of actual violence being conducted. We submit that terrorism, as defined by national legislatures, incompatible legislation is anathema. And here Parliament has legislated compatibly to define what acts are within the definition. It isn't just simple criminal damage, but serious damage accompanied by violence or arrest. The case is similar in that respect to ROJ TV, where the organisation in question, the PKK, was a designated terrorist organisation. So Parliament has decided compatibly with the Convention what amounts to terrorism, and Palestine Action is engaged in it. That action is not protected by the Convention, we submit.
So is your position that if an organisation falls within the definition of a terrorist organisation under the Act, so that the power to prescribe arises, there is never any Article 10, 11 engagement?
Well, my lady, that is the consequence of the article.
Yeah, so that is what you say. You say Article 17.
If you're in that space, with the organisation concerned. And we know what the Divisional Court found in relation to that, and in relation to Convention values. I gave you the references to 137 in their judgment. we also know we can set alongside that Rog GV case, the Sabunku case. Sabunku, which is, don't invite you to turn it up now unless you need it, but it's quoted in the judgment at paragraph 114, holding that free expression by a prohibited organisation is not protected speech, where it, quote, contains public incitement to commit terrorist offences or to condone the use of arms. Again, under that territory in relation to space. Sabunku is at town at 68, pages 2593 if you need it. So the next question and the next submission relates to distinguishing, as it were, between the conduct of Palestine Action, which is the subject of a proscription which is challenged, on the one hand, that their actions are the antithesis to the notion of a democratic society and the divisional court's findings, on the one hand, and then on the other hand, the conduct of individuals, like my Lord the MR put to me, expressing support for or association with Palestine Action. And my submission in relation to that set of interests is that to the extent that people express support for or association with Palestine Action, they do not undertake peaceful protest. They are supporting a terrorist group, the actions of which are inconsistent with democratic values and the rule of law. And they are doing so in circumstances that engage what the Supreme Court in ABJ, don't invite you to turn up unless you want to, but what the Supreme Court in ABJ at 103, 103, Authorities Bundle 49, page 1820, what the Supreme Court identified as being, quote, clearly a strong public interest in preventing the spread of terrorist ideology through propaganda or public encouragement. That was the underpinning effect of the proscription regime identified by the Supreme Court. By contrast, it might be thought, where people undertake peaceful protest without any link to the organisation concerned in terrorism and without breaching the prohibitions that Parliament has required in the event of proscription, where people are undertaking peaceful protest of that kind, they don't fall within the scope of the proscription regime at all. And there is plenty of scope, therefore, to protest lawfully, as again the Divisional Court found. See paragraphs 117 of their judgment and 136 of their judgment. It remains, as the Divisional Court correctly found, open to people to support the Palestinian cause, to protest against Israel's actions in Gaza, and we note that the target of the protest, you can protest against the arms trade that supplies Israel. The target of the protests in this case, none of those protesting activities in relation to those systems are unique to Palestine Action. But the Convention values protect the rule of law. The cornerstone of that is to require individuals to obey the prohibitions laid down by Parliament and not to breach the criminal law. If people wish to change the law, they can access the courts for that purpose, as is perfectly properly being done in this case. They can advocate a change of law in all the ways that are permitted and available in a democratic society. The Court of Appeal said in Trolan, persuasion is very different from attempting through physical obstruction or similar conduct to compel others to act in the way the defendant desires. But there are plenty of lawful mechanisms consistent with the prohibitions Parliament has set down for that opportunity to be undertaken. And we respectfully submit for all of those reasons, which are centrally focused at the Article 17 stage, on the justification, as it were, for the proscription of Palestine Action and the assessment and characterisation of what they are doing or have done, we respectfully submit that those matters fall outside the scope of the protections that the Convention affords. And it would be an odd position, I respectfully submit, for an
Does
organised...
this cut across your bank mallet argument on the policy ground?
Sorry, I'm not following that.
So, bank mallet is convention compliant assessment of proportionality. Your position on ground one, policy ground, is that it's bank mallet style proportionality, not some open textured proportionality exercise. Does this argument, your argument, not cut across that as well?
Well, my lady, not necessarily. I mean, that is a... that might require the Secretary of State to do what is a strictly unnecessary exercise in ECHR terms, which is to consider proportionality in that sense. But she might be wise to do that in any event, against the possibility that this more extreme test is not met in fact in an individual case. I think I put it. I mean, strictly you're right. Logically, this doesn't arise, and you shouldn't be required to do that in that proportionality balance if you don't reach that stage of the analysis. That's not to say it's not a good idea to do it anyway, just in case. See the Divisional Court's judgment. That's all I want to say on Article 17. Prescribed by law is a one-liner. It stands or falls with the policy argument. So fair balance is the next and final stage of the analysis.
Less intrusive measures? Less intrusive measures.
Less intrusive measure. Well, no one's directly focused on that. My learned friend seeks to do that.
In his respondent's notice.
Yeah, I can come back and pick up those points if I may.
All right.
The only thing to say perhaps about less intrusive measures at this stage is that, as you know, the test under less intrusive measures is whether or not the less intrusive measure that is identified would as well achieve the legitimate aim. And what that does is to emphasise that that's a relative question. So you can't just identify that there is an alternative measure.
Yes.
But it also introduces margin into that exercise too, because that is a question of judgment, of relative judgment. And we respectfully submit that none of the ways identified under that code touch that true test, and not as effective at achieving the overall objectives that are sought to be achieved by the regime that Parliament has laid down for prescription. That's what we say about that at this stage. Fair balance, then. There's a preliminary point, as there always is at this level now, after Schridler, about what the correct approach for the court to take is. Is it a review or a fresh assessment? My sort of answer to the words will have this ad infinitum. And the question is how to apply Schridler in any particular context. You're well aware, I'm sure, of the factors. If you want the test again, it's in Schridler, Supreme Court, paragraph 160 to 162, particularly Authorities Bundle, tab 44, page 1593 should take you to paragraph 160. And to take that relatively shortly, the first identified factor that plays into that question is whether or not this is an assessment at the appellate level of, in effect, a legislative regime of general application, which hasn't been considered very often in the particular context before, if I can put it that way, 160. There's been no previous consideration of the application of the proscription power in the Terrorism Act to prescribe organisations. There have been challenges to POAC that have been brought to POAC, but in relation to this court, perhaps because of the, as we now know, inaccurate conception or perception that POAC was the only game in town, which we know now not to be true under the legislative regime, but there's been no previous consideration in that way. this is the first examination of proportionality in the prescription context. And so we respectfully submit that we're applying the factors in Schridler. This is more likely to be a case in which the court exercises its more intrusive and less appellate function, if I can put it that way. But even if we're wrong about that, our arguments on the substance of the fair balance point hold good. We respectfully submit on any appellate standard in any event. The overall approach to fair balance is clear and well established, and the court will need very little on that. The rights involved are of obvious importance, including free speech and freedom of assembly. That needs no introduction. Nor does the idea that the ECHR and the European Court operates a factual context-specific approach to proportionality. But it is evident that those rights can be interfered with, and in a justifiable way, applying the appropriate margin. And I start with margin. I'll take it very briefly, given my lady's indication for the short agenda. You're very well aware that the Supreme Court have considered that again and again and again in recent years. And they have done so essentially according a pretty substantial margin to the executive in this sort of decision-making context. Let's see, for example, in relation to Schridler at 123 and 126 to 129, Authorities Bundle, tab 44, page 1582. And there's a pretty much unanimity of view and approach in the Supreme Court when the context involves security issues, national security issues, and indeed issues in relation to the protection of the public. Particularly when one is weighing, as one is inevitably here, security risks, their prospective element, the necessarily prospective element, bear in mind the escalation point in particular, and weighing the benefits against all of that in this sort of context. And the reason for that, you've already seen from the ABJ case, that these are on consistent authority. The reason why margin is particularly broad in that context in relation to that set of issues is institutional competence and democratic accountability. Again, you know all the case law on that because the Supreme Court has set it out again and again, starting with Lord Hoffman and Raymond, working through into the Bagan case in the Supreme Court, and most recently in relation to that in the U3 case. Just going to go very quickly to U3, if I may, to show you the relevant passages. That's behind tab 40 of the Authorities Bundle, page 1453. 1453. Tab 40. I'm sorry to go to any of these, but in part I slightly do so because in the divisional court there was a bit of, you don't need to tell us about margin again, and so I didn't. And then we get the judgment that we got, in which none of these authorities are cited, and there's a problem with the margin approach, I suppose. So U3. The key bits really start in terms of analysing how risk should be approached and the different approach that the court adopts when it's considering national security with its inevitable consideration of risks. And it's drawing a contrast between risk analysis and proof of facts to the balance of probabilities. Perhaps not that direct issue is not so relevant. You see that beginning at paragraph 55, page 1447. Can I just invite you to cast an eye down the first two sentences of 55 and the first sentence of 56. And very quickly, if you would, on the same theme, 58. This is, I may respectfully say so, the marvellous illustration of that by Lord Brown. picking up a slightly different point in relation to the primacy of the Secretary of State. In other words, the primary decision maker is, under the relevant statutory regime, the Secretary of State. That's at 63 on bottom of page 1449. Probably just need the first half of 63 down to just above the letter H on that page. And they come directly then to margin between 65 and 68, and those are the last passages I invite you to read. That's where you get institutional competence and democratic accountability and all of that. So 65 to 68, if you can just cast them out. Can I invite you to go from there, if I may, back to the ABJ case? Touched on a bit of this already, but if I could invite you for this purpose, please, 49, and I want one little section of 3 paragraphs starting at 1821. Tab 49, 1821. And can I invite you to read the sideline passage, which runs from 106 to 108, the end of 108. And you'll note in particular, lots of that is familiar. It's of some interest, at least, to note the final sentence of 108. Only because it's dealing with a context in which they do some things that are okay and some things that aren't. So, at least a level of proportionality, that doesn't help. So those are the principles, once you've already taken time on that, and they have a long and learned history through Raymond, Lord Carlisle, Supreme Court in Bacon, and they're all very familiar now, and it's almost become an answer. But all of those authorities, none of which I emphasise, not one of which was identified in the Divisional Court judgment, they all indicate, for all of the various reasons that are given, institutional competence, democratic accountability, primary decision maker is Secretary of State, and indeed in relation to the parliamentary regime, the primary legislation, Parliament itself, they all indicate that wide margin is appropriate, even in the context, because that was ABJ, of a set of criminal offences that flowed in the context of freedom of speech. Article 10, Article 11, no distinction between those two in this purpose. And in those circumstances and in that context, I respectfully submit that the judgments involved and that are of relevance here, and the margin applies at both parliamentary and Secretary of State levels. In relation to Parliament, it has decided what the test for terrorism should be, and it has set that out in primary legislation. Serious damage to property being one of the alternatives. It has decided what concerned in means. It has decided that if an organisation passed that test and is proscribed, there will be an impact on the rights and freedoms of other individuals who may not have engaged in violent conduct, may not have passed the test of terror, and there will be an impact on them. But there will be an impact on them which is secondary and is judged by Parliament to be necessary in order to enable the state to degrade the organisation which has been involved in those activities. And moreover, in that context, Parliament has decided that this isn't a pick and mix. This is a suite of prohibitions that apply to those who would otherwise be engaged with, to use that term loosely, the organisation that's concerned itself with terrorism. and those judgments are for it to make. It's done so in primary legislation, and that primary legislative scheme is compatible. Secondly, the Secretary of State. She has decided that they fell within the statutory definition of terrorism, serious damage to property accompanied by some violence, with some borderline action as well, as we've seen, that is in some circumstances more serious even than the damage to property, but with an escalating feature. She has decided that the risks and benefits which she's weighed favour proscription. And again, the margin that is to be accorded to her is significant. And it's significant for all of the reasons that have been identified by the court. She's the primary decision maker of identified. She is institutionally competent because she is advised by the range of experts that you have seen, the Counter-Terrorism Police, JTAC, and others. And she is democratically accountable. All of those reasons of principle, the margin that is to be accorded to her is very significant at all stages. And as we know, that democratic stamp, as it were, on her decision-making has included the affirmative resolution process. That is not to say that the decision is not her responsibility legally, it is. But it's another feature that emphasises the margin that is appropriate. And as we know, and as Schridler makes absolutely clear, where once there was a debate around whether or not the margin should apply at some or all stages of the four-stage bank test, we now know that it applies at all of them, as Schridler indicates. The approach of the divisional court, I respectfully submit, paid insufficient attention to that principal framework and its consequence in terms of margin. The closest they get to it is by saying at 138 that they were according to the Secretary of State, quote, some latitude, given that she has both political and practical responsibilities to secure public safety. But the judgment does not then indicate how that latitude worked, what degree of weight was attributed to it, how it played into the balance struck. And with the greatest respect to them, ultimately, it does not seem to have done at all. On the contrary, what appears to have happened is that the divisional court substituted its assessment of the evidence, of the level, scale and persistence of Palestine Action's activities, meeting the threshold of terrorism, for that of the Secretary of State. See the judgment at 140. And we do submit that that is not the proper approach. And it's particularly emphasised, perhaps, this margin point, which is why I promise this is the last point on margin, which is why I bang on about it, but it's particularly to be emphasised here, because as the divisional court rightly emphasised, or at least emphasised at 138 of the judgment, this was a case in which the divisional court recognised that, quote, where the balance should be struck in this case is difficult. But if you're on the cusp, that's precisely where margin is interesting, I submit. That's all I want to say about margin. In relation to the fair balance test itself, the first submission we make is that the analysis of the divisional court was too narrow.
On your premise, we are not, I understand why you would want to make the points if you have criticisms to make, but actually, if you're right, we're actually carrying out a fresh assessment, aren't we? If you are right,
yes.
under Schridler, we are carrying out a fresh assessment, not a review.
Yeah, on the Schridler test.
But I mean, I'm not stopping you from making, just want to be clear that if you are right about
That's
that,
the
then
consequence of Schridler. That's the judgment.
it may be interesting and it may be fair comment, but it's actually not. We have to start from fresh. Yeah.
Yeah, I'm going through
But you say the divisional court approach was too narrow, referring only to 3 past incidents. That's what
Yes,
you
I
said.
do. My lady, I'll spin through these points.
Yes. No, I'm not. I don't want to stop you. I just want to make sure that we're on the same
Yes.
page. If you're right
You
in the
are.
analysis.
You are. That's the consequence of the Schridler
Yeah.
analysis. You either do it yourself or you apply the ordinary wrong approach, at which point you have to do something slightly different.
Yes.
How different is the question of judgment? So that's what we say. Too narrow is the first point. Evident from judgment 140, the divisional court's analysis was expressly limited to the level, scale and persistence that Palestine Action's activities had yet reached. And it is of some interest, perhaps, to note 140 of the judgment, because there is at least a question in relation to that paragraph, perhaps a little more than that, as to whether or not the policy analysis has in some way fed through into this convention analysis. So that they're only looking at acts of terrorism, they're not looking at the broader picture. It's almost as if the public law policy point has in some way fed through into the convention.
Well, logically it must. If their view of policy was that it was only terrorist activities that fell within it to be considered, then logically it can have been all that they were considering when they came to do the proportionality exercise.
Well, I suppose that's right in principle, but it,
Do you see what I mean?
I do see what you
It's
mean,
got to be a
but-
lawful decision that is also proportionate.
yes, I'm just wondering whether
A
there's
policy
scope-
compliant decision that is also proportionate. That's
yeah, maybe. But anyway, it looks as though it certainly has, in fact, fed through, because they're only looking on that side of the scale, as it were, as at the things that would comprise, insofar as they would comprise acts of terrorism, and then they refer to have not yet reached the level, scale, or persistence that would justify the application of criminal law as a consequence, and so on. So there's a question about that. But in any event, the more substantive point may be that the finding itself failed to take account of the assessment which you have seen, because I've taken you back to the evidence, of their escalation in frequency and seriousness. And they don't take account of the fact, which is perhaps critical, which is that in considering proscription, of course, the Secretary of State has to consider not merely the past facts, but assess the risk in future. That's the essence. Well, that's part of the essence of it. And that takes you straight into all that line of cases we've seen, and is an integral part of the analysis which would be closed off by that. But particularly if it's highlighted by the fact that the graph is escalating upwards anyway, but the risk of future conduct is important. And I've given you all...
Sorry, do you say Arrow 140 discloses an error and failure to look
If I
forwards
need to,
and
I do.
backwards?
Well, you're saying two errors, aren't you? One is backward-looking, and two, it's just focusing on the three acts, not
And not the
Blythe
broader
Norton, and not the wider.
Exactly.
It is a close-cut thing on some occasions, yeah.
Exactly, it's both of those. I'm not going to go back over the rest, the evidence that I gave you earlier on risk of escalation. But it might be thought, as I say, the punchline of that perhaps is that everyone assessed that the thing was on an upward tick, or was likely to be on an upward tick. It certainly had been since 2024, when those incidents of extreme seriousness occurred, but it might be thought that was given real flesh and borne out by the Bryce Norton attack, which occurred very shortly before the decision was finally made. And that trend was significant in framing the likely future activities of the group, and nowhere does the divisional court take that into account in its analysis.
So, James, you say that the Bryce Norton attack occurred very shortly before the decision was finally made.
Yeah.
Do you say that it was made at the time when it was announced, or just before that? When do you say it was actually made?
Well, I say it was actually made when it was announced.
Yes.
I mean, it may be that a decision in principle is made after the MinSub has gone in and finally been considered in the usual way. And normally there'll be no or very little hiatus between the one thing and the public announcement of it. But it's always open to the decision maker to take into account circumstances between the one thing and the other.
And if that's right, when it was announced, the Bryce Norton event was at the heart of the announcement.
Yeah, it certainly was referred to by the Secretary of State, yes.
And the legal measure is the making of the order.
It is.
Not the making of the early decision.
That's true.
So that's to be factored in as well.
I suppose it is, because I suppose the new circumstances applying can apply at any stage during the parliamentary debate. You have to go through all of the processes, so perhaps formally the decision is made at that later point, which will be, I think, 5 July. No, that's when it took effect. Yes, 5 July. But it may not matter much, because the Bryce Norton thing happened before the announcement was made. Hence its reference. Second point on fair balance, the divisional court placed appears to have placed central reliance on the fact that only, quote, a very small number of its actions amounted to terrorist action, judgment 138, within the statutory definition in the Terrorism Act. 138 of the judgment. And on that second point, perhaps an A, B and a C, if I may. And the A is that the divisional court applied a test which required an organisation's core activities to meet the statutory definition of terrorism for it to be proportionate to prescribe that organisation. That's judgment 138. That is not, we respectfully submit, what the scheme envisaged by Parliament requires. The power to prescribe arises where it is concerned in terrorism, and where that definition is met, the Secretary of State judges that prescription is appropriate.
Sorry, I haven't followed this point. You're picking up on 138 of the Divisional Court's judgment.
This is only, where they say only a very small number of its actions have amounted to terrorist action.
You say?
I say you can take into account the broader canvas.
So you can take it into account?
The broader canvas.
Right.
Matters outside that.
Yep.
The starting point for any analysis of fair balance was the Divisional Court's finding that those activities had already crossed the terrorism threshold. And that was in the context of an organisation that was continuing to escalate its activities, with JTAC assessing that Palestine Action would cross that threshold again. As they put it in the JTAC report, over the next 12 months, JTAC assesses that PAG will conduct further activity constituting serious damage to property in an act of terrorism. The prospect of continuation and escalation was a serious matter, not just restricted to the past historic terrorist actions. In principle, we submit that the weight to be accorded to the number and nature of the terrorist actions that had in fact occurred, leave aside all those points about the future and risk and continuation and escalation, the weight to be accorded to them, to even the past actions, was a matter for the Secretary of State's judgment. And of course, those past activities falling within the statutory definition were made in the context of the broader picture, with Palestine Action's targets being wide, as we saw earlier when I was taking you through the evidence, targeting a series of predominantly Israeli businesses. Its organisation and funding were opaque. It had set out a modus operandi in the underground manual that you've seen. Its footprint was across the United Kingdom, and it was encouraging those who read the underground manual to act, quote, without restraint. That's the second point. Third point is the corollary of the second. It's that the Divisional Court then downgraded or ignored the fact that many of Palestine Action's activities were serious and criminal, with the line between merely criminal, if that's the concept, and terrorist under the Terrorism Act being a relatively fine one in any event. The Divisional Court found that the decision to proscribe was disproportionate, and this is 138 again, because, quote, at its core, Palestine Action is an organisation that promotes its political cause through criminality and the encouragement of criminality. As I say, the line between criminality, sometimes violent criminality, and terrorism is not a bright one. The fact that Palestine Action engaged in criminal activity which didn't meet the threshold, and that this was its modus operandi, and indeed that some of its actions did amount to terrorism because they involved serious damage to property, was not a mistake or an aberration. There are significant factors in favour of, not against, the proportionality of the prescription. And that is particularly so in circumstances where there is escalation. So Parliament has prescribed a bespoke regime, we submit, for precisely this situation, where the existing criminal powers available to the police are insufficient in their judgment to deal with the threat posed, and they need the greater armoury that allows them to go for the institution. But it was a judgment for the Secretary of State to assess whether the criminal law offences identified in paragraph 139 of the judgment, either in isolation or in combination, would adequately meet the purpose of prescription. The expert assessment of both JTAC and the CTP was that the additional provisions under the Terrorism Act were indeed necessary properly and adequately to meet the threat posed by Palestine Action. And indeed the Divisional Court had noted that evidence at paragraph 35 and not made any finding to undermine it, but then ignored it when relying on the availability of the criminal law at 139. And that was in circumstances where the evidence, therefore, from the specialist CTP in particular, was that the existing criminal prosecution powers were already insufficient. And all of that sits in the context in which the actions of Palestine Action had already crossed the threshold into terrorism, and the trend of the organisation was already one of escalation. If and to the extent that there are other powers that are relied upon, and perhaps this sits more under intrusive measures, but I take it at this stage that we submit that those points were rightly rejected by the Divisional Court as being sufficient. Must be right. And their judgment in that respect is at 132 to 134. So that's the left-hand side of the balance, if I can put it that way. In other words, the threat that is posed, the necessity and the justification for taking action against Palestine Action. I turn to the other side of the balance, which is the scale of the interference with Articles 10 and 11. And as we've already discussed, that cannot be focused on Palestine Action itself, because it had undertaken actions which were terrorist. That puts them beyond the pale in ECHR terms that we submit, and in terms of the analysis that you saw from the Attorney General's reference. So we're really dealing with the potential interference with private rights of other individuals to protest and associate. And so it assumes at this stage that there's some interference, but the nature and extent of it is important in the fair balance exercise. And the Divisional Court focused on this side of things. Correctly, we submit at 115 on those rights of those individuals who hadn't acted unlawfully and wanted to express support for or associate with Palestine.
So which paragraph?
115.
115.
The concern perhaps with that paragraph is that they describe the case as being primarily concerned about that. And in fact, the case is primarily concerned with whether or not the organisation itself should be prescribed, with the necessary and inevitable interference with A10 and A11 rights of other individuals that Parliament has decided should follow from prescription. It has taken the stage as to Palestine Action and its members, or indeed its founder, who is the claimant before you, they are very far, at the least, from the core of protection that is accorded by these articles. See, inter alia, the AG's ref for that purpose. They've engaged in violence, serious damage to property, and on occasion it appears violence to the person. That substantially reduces, at least, the protection afforded by the relevant articles and makes it very difficult for a claim of this kind to be made or weight to be given on this side of the stairs for the organisation which is the subject of the prescription. That's the first point. But the second point is that in any event, focusing on the individuals, in inverted commas, innocent individuals, the key point is that there is no bar through the exercise of the proscription power. There is no bar on the exercise of continuing lawful rights to protest in favour of the Palestinian cause, against the actions of Israel in Gaza, or against those that provide material and logistical support to Israel in its actions. There's no bar on that at all. The right to protest in support of such a cause remains entirely untouched.
Well, you say entirely untouched. That's not quite correct, is it? There are those people who are not engaging in the sorts of criminal activities that you talked about, would like to support Palestine Action, but can't do so. There are other people, another sector, whose acts might be affected by what's been called the chilling effect. They're afraid as to not knowing precisely what is and isn't allowed. So they might never have supported Palestine Action, but are afraid to do other things.
Well, yes, can I
And
take
you
that?
are stopping the right to associate
Yeah.
of people who would otherwise have supported Palestine Action, aren't you?
Can I come to the chilling effect in a second?
Yeah.
But my broader point is that there remains a very significant area in which the right to protest can still be exercised.
Yeah, you said entirely, but it's not entirely. It's diminished.
Diminished.
Yeah.
Fair enough. What cannot be done is to continue to express support for Palestine Action after prescription. And the reason for that is because Parliament has judged and has made provisions that are designed to stifle precisely that. And those consequential restraints on action post-prescription must be obeyed just like any other provision backed by criminal sanction. That is a matter of parliamentary judgment. And we note in that respect, I don't invite you to go back to it, but ABJ again in the Supreme Court, this time 60 to 61, at page 1808 of the authorities bundle, where the Supreme Court said, expressing an opinion or belief which coincides with the aims or beliefs of the organisation is not sufficient, the criminal offence they were considering there. A person can express support, in that case, for Palestinian statehood without expressing support for Hamas. I take my Lord's correction entirely versus substantially, but there is a substantial area in which you're not touched by the, should have made it a more relative submission first up, but I'll take my Lord's point on that. As to the impact through concern about the chilling effect of the order, it is significant, we submit, that the Divisional Court correctly found at 117 of the judgment that various parts, as they put it, of the evidence the claimant relies on overstate the impact of proscription. And that finding was supported by a more granular analysis of the evidence elsewhere in the judgment. So just to give you some reference points for that, proscription, they said at 117, will not prevent continuing expressions of support through peaceful process in support of the Palestinian cause or in opposition to actions undertaken in Gaza by Israel or the IDF. Nor, this is 136, would it prevent particular forms of protest action. 136 of the judgment. And then at 122, the scale of the group of people who are very closely associated with Palestine Action was difficult to estimate because the lack of information about the group was as it was, and which the claimant had failed to provide, but it was likely to be small. That's 122 of the judgment, read in the context of 18 to 19 of the judgment. So the balance was between the protection of the public at large as opposed to an impact on a small group of individuals closely associated with a group that was concerned in terrorism. And it is to be noted that insofar as Palestine Action's activities were directed against specific targets, like Elbit, they were, as it was put at paragraph 23 of the judgment, intended to close down the operations of a company pursuing a lawful business. As they found at 118, little weight ought to be accorded to those who realised, or ought to have realised, that what they were doing was in support of a proscribed group, for example, by holding signs in support of PA. This was, rather like the letter that was sent to my lady at lunchtime, a calculated action, as they put it at 118. And the possibility of policing errors, about which we heard a great deal below, was not, as they put it, a particular feature of the asserted interference here, not least because, as they found at 119 to 120, appropriate practical steps were taken to reduce the likelihood of error. And all of this in the overall context of Palestine Action's activities, meeting the definition of terrorism and being described by the court itself at 137 as the antithesis to the notion of a democratic society.
Sir James, do you accept that this could, from some points of view, be said to be an unusual case, in that in most what one might call loosely terrorist organizations, those who support them support the violence that is being promulgated, whereas here I'm taking into account what the divisional court has said. There are a body of people we know who hold up signs saying they support Palestine Action, but take no further action. So that the decision to prescribe, if you accept the point I put to you earlier today, which I'm not sure if you did or not, assume you did for this purpose, if you accept that their rights need to be considered before you decide, as the Secretary of State, on prescription, it makes it an unusual, possibly, others have said, borderline case, because there are a lot of people who are not in the usual category of terrorist supporters, who do happen to support Palestine Action, and my Lord has pointed out they're a different cohort from people who are supporting Palestine and wish to make the political points that the divisional court said could be made quite freely, even in the event of prescription. What I'm asking really is, do you accept that, and that was why I asked you the question earlier today, where do we find it in the ministerial submissions? Do you accept that it was necessary for the minister to take into account the interests of those people and their Article 10 and Article 11 rights in striking the fair balance, and possibly in considering other alternative measures?
Well, yes, is the straightforward answer to that question. But that's clear. Yes, I do, and she did. But can I also go on? Well, yes, I do, and yes, she did. But now someone reminded me of paragraph 32 of the ministerial submission. But yes, she did. Can I go further in relation to my Lord's question? It is an entirely fair point to put to me. This is not Hamas or the IRA, where there is an almost unique overlap between those who are engaged in the terrorist activity and those who support it and so on. And so it is a more difficult case from that perspective, because the rights of those who would otherwise wish to support Palestine Action are affected, and they may not have been involved in, maybe they don't even support the more extreme activities and or wing of Palestine Action. But one needs a little care in relation to that, because the whole nature and structure of the proscription regime is designed to recognise that there is value in preventing precisely that sort of support. Where the break lies between someone who has never engaged in violent conduct on behalf of the IRA, but feels passionately about United Ireland, and therefore may regard the IRA as being an organisation which advocates that cause alongside its violent activities. You've got a similar parallel there. There's a risk, however, in going too far with all of that, because the prescription that Parliament has identified is a prescription that cuts in if the organisation concerns itself in terrorism. And once it does that, and if it is otherwise appropriate to prescribe it, then the support should be cut off. And the support should be cut off in Parliament's judgment, recognising precisely the point that the Supreme Court made in 104 of ABJ, which is that there are benefits in, as it were, stopping support for that sort of organisation. Now, the reason I identified it's more than a penumbra. I accept my Lord Justice Lewis's relative point about killing may have occurred and so on. But it's not entirely clear when one takes into account the area of protest and speech that is still permissible for the cause. It's not entirely clear how many people there are who are actually desperate and keen to support Palestine Action as an organisation, as opposed to having really legitimate concerns about the Palestine people and the right to self-determination and the actions of Israel in Gaza and all of that. And all of that is still permissible. So again and again, the Supreme Court come back both to the benefit of shutting down the organisation, that's 104, depriving them of the oxygen because they've involved themselves in terrorism, but also that distinction between people who support the cause and are still able to talk to the cause, even if the cause is directly espoused by the terrorist organisation. That was the very point that was being made about Hamas in ABJ. And it could apply equally to United Ireland, or the Brits out of Northern Ireland. Those matters can be the subject of peaceful protest. The question is, truly what is the nature and extent of the interference involved in that innocent cohort? And ultimately, they have to put the damage to their interests on the basis that they should be entitled to considerable weight on this side of the balance for supporting Palestine Action as an organisation, recognising that what really underlies that is a deep concern about the cause. So that's how we put it. But my ultimate and overriding point, as I respectfully submit it to be, is that these are matters which are not easy. It's inherent in my Lord's question that that is acknowledged. But those are matters where, and indeed the Divisional Court specifically acknowledged that. Where do you strike the balance is difficult. But that's when I come back to the point that says it's a judgment for jolly good reason that Parliament has given to the Secretary of State. And it's a judgment which this court ought to respect by according appropriate margin. So that's how we put the fair balance.
Thank you very much. Jeffrey? Thank you very much indeed, Sir James, for now. Mr. Hussain, would it be convenient to have a quick 10-minute break? I think that would help. 25 past 3. Thank you very much.
But they did exactly the same.
Yeah, that's good.
Wherever they're at.
Nothing more.
No, I think they're just low on the ground.
What's going on out there? Right.
When my phone finishes. Well, shall we go?
Remind the courtroom that the live stream is still running.
And I don't mean that that was
Sometimes they're aiming questions other than
I just like
already been breached in our public judgment.
Yeah, whereas the other
3-3.
yeah.
3-3.
331, which I think should be.
Hard copy 17988.
Very tough. That needs to be struck out. Well, they needed it. I think the judgment point is to kill it. Oh, I know. Just get it's the same point, you know. I'm not sure you need to get rid of any.
Did the court artist say what her name was? Did the court artist say what her name was? It's okay, we'll message her.
That's the case. Whereas
Hi guys, is everyone ready?
Yes, thanks.
Yes, Mr. Hussain.
My lady, thank you very much. My ladies, my lords, first of all, thank you again for your kind comments about my colleague, Miss Nigrale, King's Counsel. Mr. Greenhall, in terms of division of advocacy, Mr. Greenhall will address you on two sub-issues in ground two, that is to say, scope, Article 10, 11, and Article 17, and then less intrusive alternative. I will address you on everything else.
Thank you.
So, may I please make 6 short points by way of introduction. Firstly, the first point is that the Secretary of State's decision to proscribe Palestine Action, a direct action protest group, on the basis solely of action involving serious damage to property is, quote, novel and unprecedented. That is March Min Sub Supplementary 1, Tab 10, Para 10, Hard 147, Electronic 156. It is the first time in the 33 orders laid under the 2000 Act and the 98 organisations proscribed under it that such a group has been proscribed as terrorist. The decision has rendered the UK an international outlier, as the FCDO noted in March, quote, acting in this way may be interpreted as an overreaction by the UK because the group's activity, quote, is largely viewed by international partners as activism and not extremism or terrorism. That is Supplementary Bundle 1, Tab 10D, pages Hard 183, 184, Electronic 192 to 193. Second short introductory point. It is common ground that the Secretary of State's belief, it's a belief, that Palestine Action had committed acts of terrorism was based on her assessment of 385 actions committed over 5 years since Palestine Action was formed in 2020, 3 of which qualified as terrorism, and that, as I've said, on the criminal damage limb of the definition. JTAC, Supplementary 1, Tab 10A, pages 160 to 161 hard, Electronic 169 to 170, paragraphs 7 to 8. As Amnesty International and Liberty Intervening say, at paragraphs 3 to 5, of their submissions, that's core bundle, tab 36, hard 309 to 311, electronic 463 to 465. As they say, this means that Palestine Action was assessed as having committed acts of terrorism on the basis of a tiny proportion, circa 1%, of its actions that were assessed as falling within the outer spectrum of a very broad definition of terrorism, yet the effect was to dissolve Palestine Action as a whole, and it was prescribed despite, as JTAC accepted, this chimes with observations made by my Lord the Master of Rolls, my Lord Justice Lewis, JTAC accepting that the vast, quote, the vast majority of its direct action would not constitute an act of terrorism on the basis that any damage to property is typically more minor. Common tactics include graffiti, petty vandalism, occupation, lock-ons. That is JTAC Supplementary 1, Tab A, hard, page 60, electronic 169. As regards violence to the person, it is important to see what the Secretary of State's own evidence and assessment was. In March 2025, JTAC considered it, quote, highly unlikely that Palestine Action would, quote, advocate for violence against persons. That's JTAC Supplementary Bundle 1, 10A, 164 hard, 173 electronic, paragraph 36. In the community impact assessment, Palestine Action was assessed as a criminal but non-violent direct action group. That is, same bundle, tab 10E, hard 191, soft 200. That was the consistent view before those March assessments and remained the view afterwards. I'm going to give you more detail when I come to fair balance. I'm going to do the facts once. I hope it's acceptable to do them by way of introduction in this way, but I'm going to do the facts. I'll show you chapter and verse on violence. Consistent view, not a group that advocates violence for persons, individual instances of violence, outliers, on the Secretary of State's own evidence. My client's evidence, similarly, repeatedly, is that Palestine Action have never promoted or endorsed violence against people. That's Ammori 2, paragraph 3, supplementary bundle 1, tab 6, hard 54, soft 63, Ammori 3, paragraphs 13 to 16, tab 7, hard 109 to 10, soft 118 to 119, Ammori 4, paragraph 5, supplementary 1, tab 8, hard 119, soft 128. As regards the allegation that Jewish businesses were targeted, we utterly refute that. 2 references. Mr. Andrew Feinstein, the son of a Holocaust survivor, a former MP under President Mandela's ANC government, supplementary bundle 2. I'm going to, if I may, Sir James only took you to 1 supplementary bundle. I'm going to take you to all 3. Can I call them supplementary 1, 2, and 3? If that helps.
Which is 3.
2.
There are 2 hard. There are 2. Supplementary 2 in the hard version is split into 2 bundles at tab 37, page 727. At least I hope.
I don't need to worry because I'm there.
All right. Okay, I'll. bit of a puzzle. Okay, it's one of the hardest bits of the case, perhaps. Right, so Mr. Feinstein, it's the second supplementary bundle, tab 4, hard 261, soft 267, paragraphs 17 to 18 of his statement. He says there was colossal misreporting about this. The company was a landlord of Elbit. Elbit, of course, is the primary target. And my client says the same thing. Her third statement, paragraph 8, supplementary 1, hard 107, electronic 116. The third short introductory point, if I may make it now, is that the decision to proscribe Palestine Action has caused very serious alarm and concern by civil society organisations and UN experts. So, UN High Commissioner for Human Rights himself, Volker Turk, Supplementary Bundle 2, Tab 26A, Hard 611, Soft 623, UN Special Rapporteurs holding the relevant portfolios, the intervener, Professor Ben Saul, Human Rights and Anti-Terrorism Portfolio, Supplementary 1, Tab 28, page hard 357, soft 366, Gina Romero, Peaceful Assembly and Association, that's her portfolio, Supplementary 1, Tab 33, tab 33, page 403, soft 412, Irene Khan, Free Speech. Supplementary 1, tab 34, hard 405, soft 414. Then, something that your lordships may not be aware of, I just want to give you a couple of references. The Independent Commission on UK Counter-Terrorism Law, Policy and Practice. That is an expert commission chaired by Sir Declan Morgan, former Lord Chief Justice of Northern Ireland, of course, and it included amongst its 14 members Richard Barrett, CMG OBE, former MI6 Director of Global Counter-Terrorism Operations, and Sir Peter Fahey, KPM, former National Lead of Prevent. That report is at supplementary 2, third volume in hard, tab 54A, page 967 hard, 982 soft. Mr. Barrett, he has said in terms that prescription goes too far, and that is supplementary to the third volume, tab 54A, page 1011, and hard 1011, soft 1026. That commission said.
So I'm looking at a newspaper report in the National.
That is Richard Barrett saying that prescription goes too far. The report. Do you have that? I don't want to.
I'm looking at a newspaper article.
It's a newspaper article reporting that he said that prescription goes too far.
Let's just see where this. Just my fault. Just
no, it's not your fault.
Where do we find this?
From memory, it's in the middle of the page.
All right.
If you want the commission report, that's page 967.
Yeah. No, my lady is
The
in.
newspaper article.
My lady is in the newspaper article in which.
The report may be more reliable. 967.
Yeah.
No, he says it in the newspaper article.
So 967 is a list of commissioners.
Yes, and that's the list that from which you pick the two. You get the two slots.
In the middle of the page.
Middle of the page, yes. Exactly.
Going to
Too far, exactly. Do you have that? It's just here. Thank you, my lady, Lady Justice Whipple.
But that's about designating them as terrorists.
Yes.
That's not in dispute. The designation as terrorist is not challenged.
It was going too far.
Right, I
Well,
see.
I mean, it's by reference to the consequences. It's not a kind of an issue about do they fall within the definition. I think the report's the more important document.
Yeah.
So, as my lady
the
said,
bit that you want in the report. Now, page...
the bit of the report, the bit of the page, I want page 1002 in hard and 1017.
Thank you very much. Find it. Thank you.
That's chapter 14. And in the box, they say the prescription of Palestine Action highlights several of the features of and concerns about the power to prescribe examined in earlier passages of the report. And can I just then go back to one of the concerns which we say Palestine, in their view, the prescription illustrated. And if you go, please, in hard to 969, soft 984. This is executive summary. You haven't got the entire report, just extracts from it. So in hard, I'm in 969, soft 984. One of the concerns is a definition that relies heavily on executive discretion, risks inconsistency, perceptions of unfairness, and the treatment of legitimate protest as terrorism, and so forth. Have I taken that too far? Too quickly, sorry.
Whereabouts are you on?
I haven't found it.
So it's page...
969. I mean, just so you know,
Yes.
I am looking at page 1002, and I can see a discussion of the proscription of Palestine Action. I can see reference to, in the report, to the views of UN human rights experts, but I can't see Richard Barrett in the report saying in terms it's all...
No, he doesn't say too far in the report. He says it in the middle of that press extract, that media extract.
Okay, so now we're on to another document.
That was what my Lady Justice Whipple assisted me with. At 1002, you've got a box M proscription of Palestine Action. First line, Palestine Action highlights several features of concerns about the power to prescribe examined in this chapter. And I'm just going to, by way of illustration, take you to one of them, which is in the executive summary at page 969.
Thank you.
969 hard, 984 soft, and
which is the bit that you can help us?
it's at the first, at the top of the page, narrowing the definition of terrorism, statutory definition forms a foundation and so forth. Evidence presented highlighted that its broad scope extends beyond acts of violence to a serious threat, creating uncertainty over reach. A definition that relies heavily on executive discretion risks inconsistency, perceptions of unfairness, and the treatment of legitimate protest as terrorism.
So it's recommending a more focused statutory definition.
Yes.
That hasn't happened yet.
No, but it's that is nevertheless, we say, relevant to all of our grounds, actually. Most obviously to ground 2, but to all of our grounds, for reasons I'll seek to show you. Sorry, that's not really an introductory point. The fourth introductory point, if I may, is that the decision to proscribe has given rise to a mass campaign of civil disobedience that is, on any view, civil disobedience, with record numbers arrested, over 2,000 by October 2025. You get that from that same report at page 1003 in electronic, it's 1019. And that is, of course, illustrative. The point that my Lord, the Master Rolls was making some time ago, and my Lord Justice Lewis, is illustrative of the many people who would participate in otherwise perfectly lawful activity. And they've been arrested essentially for peacefully displaying signs that could arouse reasonable suspicion of support, contrary to the strict liability summary-only offence under Section 13. Many of those arrested are elderly, many belonged to historic direct action movements. They include a former government advisor, a former retired British Army officer and member of the Holocaust Survivors and Descendants Against the Gaza Genocide Group, a former 81-year-old magistrate. And the references are Sir Jonathan Porritt, the government advisor, SB 2, third in the Hards, 46A, page 830, hard. I'm sorry that it's been copied upside down. Alternative pages there are upside down, but difficult to read. E-bundle 845, Chris Romberg, the retired British Army officer, member of the Holocaust Survivors Group, tab 36A of that same bundle, page 750, soft 762, Deborah Hinton, the former magistrate, supplementary 2, third in hard copy, same bundle, tab 39, hard 836, soft 851. Mr. Justice Chamberlain's observation on that long day, 4th of July, paragraph 53, has been proven right, we say. He said the exercise of the power in respect of a group such as Palestine Action may also have wider consequences for public confidence in the regime of the 2000 Act. And that is Authorities 2, Volume 2, if you're in the Hards, tab 45, page 1644. Mr. Justice Chamberlain, right at the beginning, consequences for public confidence in the regime of the 2000 Act. Fifth of my 6 short points, this level of public support for Palestine Action is unsurprising. They sought to prevent atrocity crimes by Israel against Palestinians. Their primary targets were UK-based corporate actors who, we say, were complicit in those crimes. For Palestinians, we address this in our skeleton at paragraphs 8 to 14. For Palestinians, I hope it goes without saying, this isn't simply an ideological disagreement. Mr. Al-Naouk, tragically, a journalist from Gaza whose father, sisters, brother, 12 nephews and nieces were killed in an Israeli strike that leveled their apartment building, says that, and this is supplementary 2, hard supplementary 3, tab 50, page 877, soft 892, and at paragraph 8, that's the reference for his family members being killed. He says at paragraph 10 over the page, so it's hard 878 and soft 893. I did not come across the Israeli arms trade as a subject of research or intellectual interest. I was born under its boot. The trademark logos of Elbit Systems and other companies aren't simply symbols of an industry with which I disagree. They are the emblems of our subjugation. They are the polished corporate face of our people's annihilation. Ms. Ammori herself explains in her statement, during my entire life, Palestinian people have been subjected to an inhuman system of apartheid, ethnic cleansing, dispossession that has devastated our communities. Now our people are facing their very destruction, genocide. That's Ammori 1, paragraph 4, supplementary bundle 1, tab 5, hard 44, electronic 53. And then the final point, if I may, final introductory point, we say there is a reason why the Secretary of State's decision is unprecedented, and that is because we have a long and honourable history of accommodating protests and demonstrations where people break the law to affirm their belief in the injustice of law or government action. I'm not contending here for a second for a legal Alsatia as far as criminal law is concerned, but rather that treating such a group as terroristic is not acting with the restraint with which Lord Hoffman said should be the reaction. And I'm not going to take you to the famous passage from Lord Hoffman in the Margaret Jones case. Just for your reference, it's Authorities Bundle 1, tab 17, page 519, para 89. But I just do want to give you a reference to the facts in that case to explain to you what restraint meant. When Lord Hoffman talked about acting with restraint.
Which tab was it?
17.
17, beg your pardon.
17, para 89 is the famous quote. Page 518. But what is often overlooked are the facts in Jones. And you see them from Lord Bingham's speech. The facts in Jones, and they illustrate what amounts to, quote, a sense of proportion, in Lord Hoffman's words, in this context. Lord Bingham, at paragraph 3 and paragraph 7, and those are the pages 494 F to G, mercifully the same hard and soft, and page 496D, he summarised the facts in the so-called Fairford appellants. Their protest concern was organised. They contested guilt at trial. They broke into a US airbase with the intention of destroying or damaging a runway, setting fire to aircraft, and obstructing or disrupting the maintenance of security so as to prevent the bombing of Iraq, which they said which they said amounted to the crime of aggression in customary international law. And then there were another group, Marchwood, and their facts are summarised at paragraph 5. As Amnesty International CEO, Mr. Sacha Desmouk, said in his second statement, having outlined the history of the tactics of Animal Liberation Front, Trident Ploughshares, Climate Protesters XR, JSO, and Insulate Britain, he said at paragraph 17 of his second statement, supplementary 2, hard copy 3, page 1097 hard, page 1042 electronic. He says at paragraph 17, it has been the consistent policy of the British state to respond to civil disobedience and direct action protest movements through a combination of policing tactics and developments in the criminal law. The forms of activism that Palestine Action have engaged in are not new and are equivalent to, and in some respects lesser in terms of severity, forms of activities that have not been treated as terrorism in the past. You'd be very glad to know. I'm going to close this section now by simply saying to you, as my client said, the aim of terrorism is to take lives and hurt people. That is the opposite of what Palestine Action are about. That's Ammori 1, paragraph 2, supplementary bundle 1, tab 5, hard 44, soft 53. May I please address you on the statutory framework, because it's obviously of general relevance. I've got 3 points on the statute and 3 points in response.
Before you move away from your 6th opening point,
yes,
I wanted to ask you either now or later to address the question covered by the Divisional Court at paragraphs 21, 22 and 23, namely the dictum of Lord Justice Leggett in the case of Quadrilla Boland.
Yes.
And what I wanted your submission on, please, is the question of whether the Divisional Court was wrong to suggest that the kind of action which Lord Justice Leggett was talking about as civil disobedience is the kind of action that the majority of Palestine Action engage in or not. In other words, do you say that they were wrong to imply anyway that Palestine Action didn't fall within the ambit of Lord Justice Leggett's civil disobedient organisation, suffragette type, where you go and say, I am breaking the law, arrest me.
Yes.
I will take the consequences, nothing covert, but I'm quite happy to be arrested because I am breaking the law to draw attention to my cause. Yes. And what I want to ask is that what you say PA is? And if so, why?
I think the answer's slightly involved. I think it's going to be yes and no. It's going to be yes and no. We're going to show you the evidence which shows that the suffragettes, of course, committed arson at Westminster Abbey. We're going to say that the civil disobedience that Lord Justice Leggett is talking about is based on a Rawlsian conception of civil disobedience. John Rawls, the famous critical.
Yes. Yeah, I know, Mr.
Sorry.
All right.
I'm so sorry. So that is civil disobedience in a narrow sense. That is what's going on now. That's Rosa Parks. That is the letter. That is purely peaceful. It's public. You don't contest. You're motivated by the public good, if you like. I'm just saying this off the top of my head. There are other aspects of Palestine actions that were in a broader category of direct action, that is tolerated by the law, or rather it's accommodated by the law, by restraint. Not a criminal law Alsatia at all, but restraint, and certainly and treating that as terroristic, we say, criminal damage, 1% of activities, terroristic is the antithesis of restraint. That's the short answer. Can I come back to that?
Thank you.
The statute, if I may. So 3 points on the statute. Would you mind just having tab 6 open? There are 3 points that I want to stress. I'm sorry if they're very obvious to you, but I just want to take it fairly quickly. First, the definition of terrorism in Section 1 is very wide. Second, and I'll explain to you why. Second, if it's not obvious. Second, the test for prescription in Section 3.4 believes concerned in is very wide. And third, the effects of prescription are severe. We say that these features of the Act underscore the need for guardrails, both at common law and under the Human Rights Act, and the importance of close curial supervision, and that Parliament must be taken to have conferred the prescription power with all of that in mind. So firstly, the breadth of the definition. Can I take you to Gaul? Sir James mentioned it, but it didn't take you to it. It's important for showing judicial recognition at the very highest level of how broad the definition is. And this is authorities, if you're in hard authorities, to tab 23. And this is a seven-member Supreme Court, Lords Neuberger and Judge giving their judgment. Everybody else agrees with them. And the first paragraph I'd like to take you to is paragraph 26. The judgment begins at page 769. Paragraph 26, page 775, letter F. They endorse another judgment in RF. They say, paragraph 26, the definition of terrorism in section 1 is, at any rate on the face of it, very wide. Point was well made in RVF. Please just cast your eye.
Sorry, I'm in Gould. I'm at paragraph 36.
20, did I say 36? I'm so sorry, my lady.
No.
26.
Thank you.
Sorry about that.
No, my fault. Shall we go? Thank you.
Page 775.
Yes.
You have that. And then over the page, 27, just cast your eye down, please. It's a tripartite definition by reference to action, by reference to design, by reference to purpose. And then 28, as a matter of ordinary language, the definition would seem to cover any violence or damage to property if it's carried out with a view to influence the government in order to advance a very wide range of causes. It would appear to extend to military or quasi-military activity aimed at bringing down a foreign government, even where that activity is approved officially or unofficially by the UK government. Para 29 against letter E. The definition is very far-reaching indeed. Thus, on occasions, activities which might command a measure of public understanding, if not support, may fall within it. For example, activities by the victims of oppression abroad, which might command a measure of public understanding, even support in this country, may well fall within it. And then, please, can I ask you to look at para 34 across the page 777. In his recent second report, Mr. Anderson, as he then was, it's of course Mr. David Anderson, Lord Anderson now, again referred to the definition, describing it as remarkably broad, absurdly so in some cases. And
he said it grants unusually wide discretions to all those concerned, but luckily they appear to be responsibly exercised.
That's isn't that the issue? And then at paragraph 62, just towards the end of the judgment, the Supreme Court say, 62, acknowledging that the issue is ultimately one for Parliament, we record our view that concerns and suggestions about the width, which Mr. Anderson has identified, merit serious consideration. Any legislative narrowing with its concomitant reduction in the need for exercise of discretion under Section 117 is to be welcomed. That's the DPP's requirement, DPP consent, provided it's consistent with the public protection to which the legislation is. It's a very unusual passage. The Supreme Court to say that legislative change is to be welcomed. You get that every day. And then Al-Siri, can I just take you to Al-Siri, please? This is in the same bundle, tab 21. Another Supreme Court case. It's a refugee case. It's a case about exclusion from refugee protection under Article 1F of the Refugee Convention, in particular 1FC, acts contrary to the purposes and principles of the UN. Can I take you straight away to paragraph 36, which is at page 621. You'll pick up the broad issue there. Basically, the court says, and this is Lady Hale and Lord Dyson, with whom Lords Kerr, Wilson and Phillips agreed, the court says that the Section 1 definition that we've just been considering in Gore had to be read down in the light of EU law. That's page 621E to F. But the punchline is at paragraph 39 over the page at 622, where the court says, the essence of terrorism is the commission, organisation, incitement or threat of serious acts of violence against persons or property for the purposes of intimidating a population, compelling a government or international organisation to act or not to act in a particular way. So we say that is Supreme Court authority for what the essence is. Of course, I'm not saying that the Section 1 definition cannot be applied or the Secretary of State errs if she proceeds on that basis. I'm not saying that for a second. I'm simply saying to you that what we have here is engagement on the basis of 1% of activity over 5 years in the outer spectrum of what is at times an absurdly wide definition of terrorism. Absurdly wide, not my phrase, you'll see. That's the first point, the breadth of the definition.
The definition, I was just looking at Article 1F, it's page 610, paragraph 3. That doesn't actually include terrorism.
The question was, sorry.
That doesn't include terrorism.
No.
It's got crimes against peace, a war crime, serious non-political crime, and they were treating what they call terrorism in that case as something that falls within that. But they weren't trying to define Section 1, were they?
No, not at all. The reason the issue was live, because they held that the Immigration Act, I think it was Section 54 of the relevant Act, it applied the Section 1 definition. They said they could read that down because of the EU law. That's what you get at paragraph 36.
How does it help us with interpreting the provisions of the 2000
2000
Act?
It doesn't.
Oh, it doesn't. Oh.
It doesn't help you. What it helps you with is what the Supreme Court think is the essence of terrorism. The essence of
Why is that not reflected in the definition of terrorism in the Act?
in international law, because the issue, obviously, for present purposes, the definition is as the statute has it. I completely understand that.
Well, what is at odds? What is the?
What's the point of this?
No, yes. Why? This is paragraph 39 tells us what the essence of terrorism is. Is that in conflict with Section 1 or supportive of Section 1?
No. It's not in conflict with it. But what it gives you is that Section 1 definition is very wide and captures terrorism, captures activities as terrorism that the Supreme Court think are not at the essence of it.
It's my problem, I'm sure, but I'm looking at paragraph 3, and what they're actually defining is a serious non-political crime against outside the country of a refugee prior to his admission to the country as a refugee.
Yes.
And the context of taking away refugee status. So they're actually defining a serious non-political crime.
No. So that's A, 1FA.
Right, so
Here,
what are they actually interpreting then?
acts contrary to the principles and purposes
Okay.
of the
So
UN. Sorry, I took that too quickly.
I'd like to know what they're interpreting and whether they are actually interpreting terrorism or using terrorism as a synonym for something they are interpreting. In a sense, it doesn't matter because you've told us the one thing they weren't doing was dealing with Section 1 or whatever it is of the Terrorism Act. But it would be useful to know what they were doing if we're going to treat the words of 39
So I took it
as
too
having
quickly.
relevance.
In fact, it's the paragraphs I told you. I took them too quickly. I'm sorry. Paragraph 36, if you read that.
36.
Let us see. It is clear that the phrase acts contrary to the purposes and principles of the UN must have an autonomous meaning. That's what they're interpreting.
That's the phrase they're interpreting, yes.
Yes. And that's 1FC. It's not serious political crime. It's 1FC, the refugee definition.
And that's not
Refugee
an
Convention.
autonomous meaning.
Sorry, yes, autonomous meaning, one true interpretation, as yet no specialist international court to adjudicate upon. Refugee Convention, UNHCR guidance isn't binding, and then qualification directive, do you see that just above letter F? Within the EU, the directive is designed to lay down minimum standards. Lord Justice Sedley correctly concluded that the adoption of 54.2 of the 2006 Act, of the meaning of terrorism contained in the 2000 Act, has, where necessary, to be read down in a 1FC case, so as to keep the meaning within the scope of Article 12.2c. Terrorism is contrary to the purposes and principles of the UN. The question
I've
is,
got it now, yeah.
in this case, what did it mean? And so you had to read it down. I don't have any tool or hook by which I can say that you should read section 1 down. We don't say that you should read it down. We're simply trying to show you that what the essence of terrorism is what the Supreme Court said at 39, paragraph 39. And we are somewhat at the penumbra. That is relevant to policy, it's relevant to proportionality, in fact it's relevant to due process, in fact it's relevant to discrimination. I can explain why it's relevant, a bit more involved. Due process, because it catches a very wide range of people. Discrimination, it means that the comparator class is going to be wider than it would otherwise be. That's slightly involved. But it's obviously relevant to policy. It's obviously relevant to whether proscription is proportionate. The fact, and it's just not enough at all to say, well, you fall within this, quote, absurdly wide definition. Not my phrase. Concerningly wide definition. Not my phrase. Obviously not enough to say, you fall within that, bingo, you're out. That's the point.
So definition of terrorism very wide.
Definition of terrorism
Test for prescription.
Sorry?
Test for
Test
prescription.
for prescription, my lady. 2 points. Firstly, as Sir James said, the test for prescription in section 3.4 of the Act does not require there to be any sense in which the activities that fall within section 1 preponderate in the organisation, and it is the condition precedent is belief. I accept it's reasonable belief you would read that in on first principles, and the Court of Appeal has in fact done that. In the Lord Walton case, you don't have one of the authorities you don't have. I accept it, you can interpolate reasonable belief. Section 3.4, Secretary of State may exercise the power only if he believes it's concerned in terrorism. So it's belief, and as Sir James says, no express restriction to the activities being terroristic, but in terms of the majority of the actions, you could have one. You could have one. So the prescription
so
test.
Mr. Hussain,
Yes.
you're focusing on the number of acts.
Yes.
But for my part, and to help me,
Yes.
and maybe tomorrow, and speaking only for myself, it would help me if you could explain by reference to the manual
Yes.
how that manual supports the idea that it's only 1 or 2 incidents when the cells that are recommended are given the guidance contained in the manual.
Yes.
So I think it's
will.
important, I mean, of course it's important to focus on 3 out of 300 acts. I understand that completely. But it's also important to focus on the organisation more broadly, to explain why you say that is symptomatic of a civil disobedience organisation, effectively.
In fact, we've got evidence about that. I'll address you.
Yes.
I'll do it in one go.
Of course,
if I may.
I'm just giving you
Thank you. It's
notice
very helpful.
that would be interest.
It's
of
very
interest.
helpful. We've got evidence on it. In fact, there's a CTP assessment on the manual. They say it's not enough to trigger prosecution. having it isn't enough. They said that some time ago, I think 2024.
Right.
There's a lot of material on that. But I'm on the second point, the breadth of the test for prescription. You have the point, it's wide. And then the severity of the consequences, the low threshold. First point I would make, I'm sure you're well aware of the consequential criminal liability which prescription gives rise to. But I just want to make a couple of points. The low threshold for a prosecution, reasonable belief, means that the offences concerning belonging...
Sorry, low threshold for prescription.
For the discretion to prescribe.
Yes, you said prosecution.
Did I?
Sorry, so the low threshold for proscription, yes.
For proscription, reasonable belief, means that the offences concerning belonging, support, and displays of membership in support in sections 11 to 13 are committed inter alia on the basis of the Secretary's reasonable belief that the organisation of which the individual is alleged to be a member or which is alleged to support is concerned in terrorism. That's striking. So you've got a belief, X organisation is a terrorist organisation, no requirement that it preponderate in committing acts of terrorism, no requirement as to frequency, no requirement as to proportion. A small number would do. And then you hold a sign up and you've committed a terrorist offence. You've got extraterritorial application in section 17(2)(c) for belonging, punishable up to 14 years imprisonment. Criminal offence, section 12(1)(a), criminal offence for a person even only recklessly to express support. 14 years imprisonment. Again, for UK nationals, sorry. For UK nationals or residents, it's extraterritorial. Section 17(2)(ca) and 3(a) of the 2006 Act. And then section 13, the section which I referred to earlier, criminal offence for a person, strict liability, no culpable mental state necessary to display or publish an image or article if it could arouse reasonable suspicion that the individual supports the organisation, even if that's not the individual's intention. Section 13, 6 months, summary only. And for UK nationals or residents, that can be committed anywhere in the world. Section 17(2)(c)(b) and section 3(a) of the Terrorism Act 2006. And there are other offences, but you get the drift. Extremely severe, deliberately so. It's intended to destroy the organisation. May I make 3 points? That's 3 points on the Act. 3 points, please, on Sir James's submissions, and they relate to his idea that Parliament afforded primacy to the Secretary of State, to the executive. Secondly, she has no power to tailor. It's a fixed suite. And C, we are really dealing with a legislative choice. So first point, executive primacy. Sir James said that, his skeleton says it at paragraph 8. We say, with respect, that is a surprising contention. There's no indication of that in the statute. It's clear, we say, that Parliament contemplated that the exercise of discretion would be subject to common law and convention constraints, not just common law. I'm sure it was a slip Sir James says public law constraints, statutory as well. Section 6, Human Rights Act. There is no attempt at ouster or quasi-ouster. No shall not be questioned clause. And the open-ended discretion is obviously subject to Section 6 of the Human Rights Act, even on the sort of Justice Scalia originalist approach to statutory interpretation, which you might recall Sir James urged on you at one point back in autumn. But even on that, so you see amnesty at paragraphs 6 to 8. That's Core Bundle 36, pages 311 to 312. They make a series of points about the timeline. Basically, this act gets royal assent in July 2000, but the prescription power is only commenced after the main provisions of the Human Rights Act had been brought into force. They make the point that Section 9 in the 2000 Act expressly ensures that Human Rights Act challenges can be raised before POAC. Clearly, Parliament contended that the Human Rights Act would constrain the exercise of executive discretion. I don't need to say that the Human Rights Act, if you're into implied repeal or anything like that, Sir James doesn't say you are, that it's a constitutional statute, Lord Justice Laws, the late Lord Justice Laws, in the Toburn case. So the statutory framework has got to be considered in the round rather than simply by reference to the 2000 Act considered in splendid isolation. Second point, no power to tailor. Secretary Skeleton 10, Sir James repeatedly made the point, fixed suite, no power to tailor. Now that, we say, is very much a point against him because it underscores the proposition that prescription is a very heavy power. Amnesty have cited Hansard for mischief under the rule in Williams and Nigeria. It's very obvious it's a very heavy power. You don't need Hansard for that. And there need to be guardrails, common law, convention. And this is really important because, as my lady will certainly be aware, the decisions of the courts in cases like Chowdhury, PWR, and indeed now ABJ, and I think also in Sati, my lady was in Sati, that the consequential offences don't admit of Article 10 to 11 defences because their proportionality is ensured, baked in, if you like, by the elements of the offence. But that, of course, renders the need carefully to scrutinise the gateway prescription decision all the more important. It's absolutely critical that you look at the exercise of the prescription power for compatibility with inter alia, the Human Rights Act, if down the road nobody's going to be able to raise that compatibility when they're facing 14 years imprisonment or 6 months imprisonment, summary only, strict liability. The lack of tailoring in the statute drives the need for particularly careful consideration also of the adequacy of all alternative measures which we say can be tailored to limit the nature or extent of the corresponding interference. Third point, is this a legislative choice? Obviously not. Obviously not. We're not concerned here with the legislative choice. Divisional Court held at paragraph 102, what we're of course concerned with is an executive act, not a legislative measure. Parliament conferred a discretion, may, it didn't impose a duty, shall, it didn't even impose a contingent duty, shall, unless. as Mr. Justice Swift said in argument below, nothing happens until the Secretary, and unless the Secretary of State exercises discretion. The regime obviously is not self-executing. Now, there's a gloss, and I just ask you to bear this in mind when you're looking at the Secretary of State's skeleton. There's a lot of gloss. It moves between, well, the executive can do this, Parliament did this. There's a lot of that going on in the skeleton. One example is that paragraph 11 of Sir James's skeleton. He says this, he says, Parliament intended for prescription to have the effect of stifling organisations concerned in terrorism and for members of the public to face criminal liability, etc. Now, that misses the critical executive step. What Parliament, in fact, intended was that any organisation whom the Secretary of State lawfully proscribes should be subject to those consequences, not any organisation who falls within the definition. That is why Parliament conferred a discretion and interpolated the Secretary of State's executive decision between the definition of the organisation concerned in terrorism.
The thrust of his point is, with respect, very simple. The legislative decision was to empower the Secretary of State with the discretion.
Yes.
So that's his point. So I don't think he's suggesting that it's never been suggested that it's for Parliament to decide who gets prescribed. It's for Parliament to decide who has the power to exercise the discretion.
Of course.
And for Parliament to decide what the consequences of prescription are once the Secretary of State has exercised her discretion. And you accept all of that?
Of course. Yes. But I think the point of disagreement is Sir James says he rests there. We say what that means is that, the discretion's got to be exercised commensurately with the consequences that follow in terms of common law constraints and convention rights. Sorry, I'm probably overstating.
No, I think we're all violently agreeing at the moment.
I'm glad to hear it. Ground one. Can I move on to ground one?
Yes. I see the hour. We could start 5 minutes early tomorrow, if that would help.
Yes,
25 past 10. Or 10:30 if you're on track. Doing on time.
I wouldn't. Probably quite a lot to do. If you wouldn't mind, 25.
Or start 5 minutes now, but I'm not sure that's at the end of a long day. I think let's start promptly tomorrow at 10:30.
Thank you very much.
We won't be late, barring unforeseen interventions. Thank you all very much indeed for your very help. We look forward to seeing everybody again tomorrow morning at 10:30.
Thank you very much, ma'am.